Breach of contract, one of the cornerstones of civil litigation. May it please the audience, my name's Rich Schoenstein. Welcome to So Sue Me. And I told you when I started this podcast, one of the things I was going to do is talk about some fundamental legal topics to maybe educate a little bit or try to bring them within our grasp. And I'm going to start out with as fundamental a concept as there is in the law. What is a contract and what does it mean to breach a contract? It is an easy concept, but maybe not as simple as you think. All right, breach of contract. You can't talk about a legal concept like breach of contract without some slides, so here we go. First off, what are the elements of a breach of contract claim? I'm going to start right off here with what would you have to do to sue somebody for breach of contract? These are the things you would have to prove. You would have to prove the existence of a valid contract, a legally binding agreement between the parties. I'm going to get into that a little deeper. You'd have to prove, if you were the plaintiff, that you performed the contract, that you fulfilled your obligations under the contract or had a good, legally acceptable reason for not doing so, such as the other side precluded you from performing for some improper reason. Then you have to prove breach. You have to prove that the other party of the contract failed to fulfill their contractual duties, and the failure has to be material, meaning it's got to be important to the contract. And then lastly, you have to prove damages. The plaintiff has to have suffered some actual damages as a direct result of the defendant's breach. Now, there are circumstances where you can sue somebody to compel their performance with a contract instead of seeking damages or for some kind of declaration about the contract. I'm not going to get into those today. That is more complex than this episode wants to be. Generally speaking, you have to prove damages. So with all of that in mind, your threshold question is, what is a valid contract? What is a contract? And I'm going to take, by way of example, a contract between two people. Often you have a contract between businesses, and you can get into a whole different thing about who are the parties to a contract. But let's assume you have two people. A contract is an agreement between those people. And here's something really important that folks don't always understand. A contract does not have to be in writing, except in certain circumstances. There's something called the statute of frauds, and in New York, by way of example, if you have a contract for the purchase or sale of real estate, that has to be in writing. If you have a contract for something that can't be done within a year, that has to be in writing. But for the vast majority of contracts, you don't need a writing. You could have an oral contract. As long as you have some sort of offer, acceptance, an intent to create a legal relationship, and you have agreement on all of the material terms. What are the material terms? Well, for example, I can't agree to sell you something if we don't agree on a price. It's meaningless. If I agree I'm going to sell you my car, but we don't know what the price is, you don't have an agreement because the price would be a material term. An oral agreement can be a contract, but the problem with an oral agreement is it's hard to prove. That's the great thing about a written contract. It's there. It's literally in black and white. The terms are down on a piece of paper. If you have an oral agreement between the parties, they're probably going to disagree on what the terms are, and it's going to be very hard to prove that in a court of law, and certainly even harder to prove what are all the material terms of that contract. Finally, you don't need a writing or an oral agreement. Sometimes a course of conduct can establish a contract. Sometimes the parties can do something over and over and over again, and by doing it over a certain period of time, they establish that there was an agreement. Or there can be an oral agreement verified by a course of conduct. Courts, if they don't have a written contract in front of them, will look at a course of conduct to think about what is a contract. Okay, how are we doing so far, right? It's not so simple. What is a contract? It's not a form necessarily. It doesn't have to be in writing necessarily. It can be a lot of different things, but it has to be fundamentally an agreement between the parties, a meeting of the mind on all material terms. And if you have that, you should have an enforceable contract. Some people are unsure as to whether or not they've ever entered a contract. Let me assure you, if you are watching something on the internet, you have almost certainly entered into a contract. First of all, think about where you live. If you are leasing a place, renting a place, then you have some sort of agreement. If you own a home, then you have the agreement by which you bought the home, and you might have a mortgage. If you have a job, you have an employment letter or some form of employment agreement, either written or oral, some sort of understanding about the terms of your employment. You must have an agreement as to what you're getting paid. That is a contract. If you have loans, if you have mortgages, if you have car loans, if you've bought anything over time, there are contracts underlying all of that. Whenever you do stuff on the internet, you're almost certainly entering a contract. All of those long terms and agreements that you flip through super quickly and press accept, accept, accept on the internet. Don't worry, we all do it, but those are contracts and they contain a whole lot of terms that you have agreed to. And it's going to be assumed that you read all of that, understood it, and agreed to it by proceeding with whatever you're doing on the internet. So depending on how old you are, you've likely entered somewhere between dozens and hundreds of contracts. Now, once you have a contract, once you know that you have an agreement with someone, you got to figure out what the terms are. And again, it's simpler if you have it in writing because then you can just look at pieces of paper and figure out what it is. But even then, even when it's in writing, there might be things you don't understand. There's a whole concept in the law about whether or not contractual terms are ambiguous. Courts like written contracts. They like to decide disputes based on what's in the written contract. And if they can't figure something out, they will say it's ambiguous. And they will look to what we call parole evidence or extrinsic evidence to try to figure out what the contract means. They'll look to the history of the drafting. They may look to the way that the parties have perform the contract, again, their course of conduct. There's other legal principles. For example, there's something called contra preferendum. That's a Latin term, but basically what it means is that a contract is going to be construed against the party that drafted it. So if you wrote a contract and nobody can tell what it means, they're going to hold that against the person who wrote it for the most part. There's another principle that says you should read contracts so that all of the terms have meaning. So if we're confused about what a contract says, we're not going to read it in a way where one of the terms would be rendered completely meaningless or completely superfluous. There are so many different legal principles and rules like that, and a little bit they vary from state to state, so you have to be careful. Now, I'm not going to cover all of the terms that may exist in thousands and thousands of different kinds of contracts, but here are some key terms that can be buried in a contract that are very important. First of all, the contract may itself tell you what does and doesn't constitute a breach of that contract. The contract, especially a written one, will lay out precise terms that tell you when one of the parties is in breach. And it may also tell you that the party in breach has some kind of opportunity to cure that breach, or that the non-breaching party has to give notice, has to tell the other party, hey, you're in breach. And then the other party has an opportunity to fix it before you can go running off to court with a legal claim. And it's really important that you understand if your contract has an opportunity to cure. Even contracts that require monthly payments may have a provision that says if the party doesn't make their payment, the other party has to tell them you didn't make a payment, and then they have 15 days to fix it before you can go into court and declare a breach. The contract may also tell you more specifically what happens if there's a breach. Is there a limitation on damages? This is a big one buried in a lot of contracts. Contracts where you buy things may have a provision, for example, that if you get hurt or you suffer damage, you can't recover anything more than what you paid for what you bought. That's a pretty common term to have in sales contracts when you're buying things on or off of the internet. The contract may also tell you how a dispute is determined. Do you go to court? If so, what court? Contracts sometimes tell you what state you have to go to court in, or they may tell you you have to go to arbitration or mediation, and they may tell you specifically where to go and what are the rules. So looking at the detail of the contract is important to understand whether there's been a breach, what you have to do if there's a breach, and where you can go for dispute resolution in case of a breach. Also, I mention here confidentiality and non-disclosure terms. Those are often buried in a contract and can be very important. We could unpack contracts for days and days and days. If you go to law school, one of your first year courses, usually for the whole year, is contract. So you read a lot about contracts and you understand rules of construction, how you read contracts, how you handle disputes, and a whole bunch of different things that obviously I'm not going to get to here. But I put down these 4 rules of contracts that I like to tell people to think about just in their day-to-day existence as people who enter contracts. First rule, read the whole thing. Make sure you understand it and get a lawyer if you don't. If you're entering a contract, particularly if it's like a major contract to purchase a home or to take a job, and you don't know what you're signing, you need help. You need somebody to explain it to you. Because again, if you sign a contract, everyone is going to presume that you read it and you understood it and you agreed to it. So if you don't, you have to do something to make sure you do. Then I say, or don't read the contract, but then understand the risk. And listen, I do this all the time. I mean, I'm on the internet too. I buy stuff. They have those long form things. I scroll through them. I accept. Some things are not that important in life, and you don't need to worry about going to a lawyer to sign a contract when you're buying something for $10 on the internet. But everybody has to make a decision about what contracts are important enough that they really need to make sure they scrutinize and really need to find out if they can negotiate. And you know what those are. I mentioned contracts involving your home, contracts involving your job. Those sound like the key ones to me. I think you could come up with a whole list of things, and I think it could be different for different people. But contracts involving significant matters in your life require an appropriate amount of scrutiny. Next, keep a copy of anything important. And I say this because in today's world, we're asked to sign a lot of things online. You get something sent to you and you're asked to add your digital signature. And yes, that is a valid written contract. If you agree and insert your digital signature or authorize it some other way, that will be construed, generally speaking, as a valid contract. And I'm suggesting that you print out and keep a copy of that for future reference. Again, especially if it's an important fundamental contract, employment, home ownership, something like that, you want to keep in your file. So if and when there's an issue, you can go back to it and consult. If you think the other party is in breach, or if you're in breach, the first thing you need to do is look at the contract. I get people who call me up all the time, especially about employment matters. Can I move from this job to that job? And I say, well, what does your employment contract say? And they say, I don't know. And then they feel a little bit udgy about asking their employer for a copy of the contract because they're worried they're going to signal something. And they're probably right about that. Better practice is to keep a copy. Lastly, my last tip for today, Take immediate action in case of a breach. If there is a breach of contract on the other side, you need right away to figure out if it's really a breach, figure out what you're supposed to do under the contract, and do it. There are legal principles that if you sit on your rights, they can be waived, or there are other legal grounds that you wouldn't be entitled anymore to enforce the contract if you wait too long. And I always say, for the most part, no civil litigation matter gets better with age. If you're going to go to protect your rights, you should do it right away. So there you go. Those are some fundamentals of contracts. What is a claim for breach of contract? What is a contract? What are some things you should think about in the major agreements that you enter into in your life? One thing I would have added to that last slide, it's a better practice to get it in writing. I know I said you can have an oral contract. I know I said you can have a contract by course of conduct, but if you really want to protect yourself and you want to have the important terms enforceable, you want to have that in writing. This is a huge area of the law. Breach of contract, again, is the cornerstone of civil litigation. I always regarded it as the most important course I ever took in law school, and it's something that not everyone focuses on, even though, once again, all of us are entering contracts all the time. Enter your next contract carefully, work hard to protect your rights, get a lawyer if you need one, and come back here and watch some more So Sue Me as we delve into other topics in our next episodes. I'm Rich Schoenstein. Thank you so much for joining us. We are adjourned.